Welcome. My name is Robert Sterne, and I am the Editor-in-Chief of Patent Office Litigation, the first and definitive book on the new contested proceedings at the United States Patent and Trademark Office. It is June 2013, and almost 9 months have gone by since the new contested proceedings became operational at the United States Patent and Trademark Office. Over 300 inter-partes reviews and covered business method proceedings have been petitioned at the new Patent Trial and Appeal Board. Many of these have been ordered for trial at the board since September 2012. I have delivered 19 presentations around the U.S. on these new proceedings and have taught the ins and outs of the new contested proceedings and the new patent world to over 3,000 patent professionals. This is more than anyone else has done to date. I mentioned this to provide the context for this short presentation, which I have titled, How Best to Conduct an Oral Interview at the United States Patent and Trademark Office Central Reexamination Unit in an ex parte reexamination. There are many ex parte reexaminations still going on at the USPTO, and under the new contested proceeding rules, the patent owner or a third-party requester can file an ex parte reexamination. And there are literally hundreds, if not thousands, of ex parte reexaminations still ongoing at the CRU. So the question that I want to address today is how best the patent owner can defend their patent claims in such a proceeding. It is clear, based on my experience, having been involved in over 50 interviews at the CRU in ex parte reexaminations, that an interview at the CRU in an ex parte reexamination is absolutely essential for success. This interview allows the patent owner and its representatives to explain the story of the invention, to explain the related litigation that often is ongoing in connection with the ex parte reexamination, and most importantly, to address the rejections and the claims and why the prior art that has been asserted against these claims in the ex parte reexamination is not sufficient for rejection of the claims as is urged in the ex parte reexamination. Now, based on my experience, many people don't understand the importance of this actual face-to-face interview which one can conduct at the CRU. In fact, the CRU welcomes such interviews, particularly if the patent owner representatives are prepared and understand the rules of engagement. The patent owner representatives must rehearse their presentation several times before they go into the patent office and conduct the interview. The interview is typically 1 hour in length, although I have been in interviews that have extended for several hours, particularly if several related patents are involved at the same interview. I typically use a slide deck for help in organization of the issues that are being presented and make that slide deck part of the administrative record of the ex parte reexamination. In addition, the various members of the team that I bring are very important in being able to tell the full story of what is going on. I typically have my technical expert at the interview, along with one or more of the inventors and a representative from the patent owner. In addition, depending on the protective order in the concurrent litigation, I may have one or more of the attorneys involved in the concurrent litigation as well. And it's often the case that 2 or 3 of the inventors will be present, along with 2 or 3 attorneys from the litigation team and 2 or 3 representatives from the patent owner. All of these people have been rehearsed in moots that we conduct before the interview so that they understand their speaking roles in this very tightly orchestrated 1-hour presentation. We use the slide deck for organizational purposes. But the most important thing to remember in any of these interviews is that you are there to answer the questions and address the concerns of the 3 examiner group that you will be meeting at the CRU. If you do this and provide an organized presentation and follow it up with a full and complete written response, including the necessary declarations to create the full administrative record, my guess is that your chances for success will be significantly higher than the averages that you will see on the USPTO website. And this extra preparation of going into trial, if you will, before the Central Reexamination Unit will pay off in multiple ways as you protect the claims in your ex parte reexamination. Thank you very much.